We'll go on the record in People versus Eric Lewis. This is file number 255493. The record should reflect that Mr. Lewis is present here in the courtroom today. If I could have counsel put the appearances on.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thomas on behalf of the defendant, Eric Lewis.
Thank you. This is the date and time set for sentencing in this matter. Mr. Lewis, have you had an opportunity to go through the pre-sentence report and talk to Mr. Thompson about that?
Yes, I have, Your Honor.
Mr. Thompson, are there any additions, deletions, or corrections to that report?
Your Honor, what I would say is when I allocute, Mr. Lewis has a lot of, or has things he wants the court to be aware of regarding the contents of the PSI, the technical corrections or deletions, but we are going to be commenting extensively on the PSI for my allocution.
Okay. Are there any challenges to the scoring of the guidelines?
No challenges to scoring, Your Honor.
Let's hope that the people have any additions, deletions, or corrections.
No,
Any challenges to the scoring?
no, I believe it's scored accurately.
Anything on behalf of the people for allocation?
Your Honor, I think the court is probably pretty familiar with Mr. Lewis's behavior through the PSI. Most things are documented. Honestly, he's 34 years old. This is, I think, his 9th and 10th felony. He's got 4 misdemeanors and a juvenile record. He's currently under sentence. He is literally his own worst enemy. You know, he can present normal and he can present appropriate, and then he can be completely out of control. I did read his thing from CMH that he has voluntarily went there 18 times and wants to continue those services. I think that's great for him. But if he doesn't learn some self-control, he's going to spend the rest of his life in prison. The guidelines are 7 to 28. He doesn't get any credit because of his current situation. I don't think he's earned the bottom end of the guidelines. I would ask the court to sentence him in the middle. Thank you.
First, if I could approach, Your Honor, Prosecutor Coke referred to it, but this is a letter from CMH that does describe his attendance and his willingness to participate in that CMH counseling he received here.
Okay, thank you. I've had a chance to review that here today. Anything else you wanted to say on behalf of Mr. Lewis?
Yeah, I had several things, Your Honor. Mr. Lewis wanted the court to know, you know, obviously looking at his record, the number of felonies, you know, there's only 4 adult felonies before here today. Mr. Lewis had an extensive juvenile record that led to him sort of unprecedented in my experience, being sent to prison at 14. Really kind of a dramatic story when you read his PSI in terms of how long he had been incarcerated, what he got exposed to at a very young age in terms of adult, in terms of a prison. In this time, he did do a lot of additional programming that's referred to in the PSI, doing classes on advanced substance abuse, doing some classes on trying to get qualified as a janitor. As he had been out on parole here, he didn't have any formal violations. He did advocate to try to receive more services and benefits when he was here because he very much believes he needs additional help to become a functioning member of society. As he tells me a lot, he really has a lot of desires in that. He was making moves to achieve that. He wanted an apartment, he wanted to go to college, he was working towards enrolling in college, he wanted to have a productive life. Unfortunately, he had a very bad day here. It wasn't an aggressive thing, it was a non-compliance thing. He wasn't intoxicated that day, he was sent to jail. At some points, and I've watched hours of videos about this day, at points he does submitted handcuffing. He didn't attack officers, but there were points where he was not compliant. He advises me he was very sick that day. He'd been sick for a while. That caused him to go off his medication. He couldn't bathing down. That caused him to go off his mental health medications, and so he wasn't in his best state that day. There are times when it's referred to that he was in a fighting stance. He really doesn't agree with that. And I've watched the video, and his hands were at his side. It's a very aggressive posture from his perspective. He's getting about ready to be tased, so he's tensing up. But you know, he wants the court to know he didn't raise his hands in an aggressive way. He had them at his side, but he was tensing up because he was about to get tased, and he ultimately was tased. You know, ultimately that day, he's the person who got hurt. He's the person who bore that burden on that day. He knows he really needs help. I think he's demonstrated a lot of insight into that. He knows he needs mental health counseling, and the court can see he's participated with CMH. He has a brother who's doing very well in Gaylord. You know, he looks towards that in terms of a family member who has been able to do the things he wants to do. He did get a GED in 2007. He does suffer from mental health concerns. I think at some points it refers to his health as being in good health, but he wants the court to know he does suffer from PTSD, anxiety, depression, perhaps ODD. He was married and then divorced. In his background, yes, I wasn't clear about that. Mr. Lewis presents, you know, as someone with a very difficult record. And I don't know that it's necessarily untrue that he is his own worst enemy, but he wants the court to consider a community sanction of jail time up to the 12 months. That would be appropriate, allow him to continue to try to work on the things he's trying to work on. Thank you.
Mr. Lewis, anything you wanted to say today?
Everything my lawyer has said is accurate. You know, I do have like mental issues or whatever, and I understand this, you know, like when I'm you know, I guess faced with somebody that is talking aggressively towards me, I tend to match their energy because of the things I've been through and where I just came from. I did almost 10 years in a level 4 prison out of the almost 12 that I just did. So like, you got to understand, being a white guy and a smaller white guy in a level 4 prison does tend to, you know, reflect on you because of how long it was, you know what I mean? And I don't mean to be like that. And I have been steadily trying to change this. And as you can see, like through everything I've actually did accomplish when I was out there, I was actually trying to do normal stuff. I wasn't doing drugs or nothing like that. You know, I did smoke weed and I did occasionally drink, and my parole officer did know about this. And I'm not a liar, so you know, I was always straightforward with him. And I took my medications, and like I told you the last time I was in here, when they came in, I was sick. I was real sick, and you can verify that through the jail stuff, because I didn't eat for almost a week or something like that. I just kept puking, and like I was on like cough med, like all that, you know, NyQuil, DayQuil, Corazine and stuff. You don't get that in prison, so like that was all new to me. You know, you don't get any type of, you know, narcotics, so to speak, like that. And then being off my meds, you know, I was real highly emotional and stuff like that. You'll see in the video, if you watch the video, that I was sleeping. I was complying up to the whole time. And like I said, I don't even know why I said I ain't saying shit when they told me to send the chair. It didn't even make sense. At first, I thought it was just literally like a typo or something. And then when I seen the video, I'm like, damn, why did I say that? They don't, you know what I mean? Like, I'm complying up to this point. Why would I be like that? And then they try to force me into the chair. And I don't know. I wasn't in the right state of mind. I ended up apologizing to one of the cops, a younger guy, for it. And I told him, man, that's my bad. You know, like I'm trying to do right. I had a job out there. I was about to start college, and on November 4th, all I had to do was the FAFSA and just waiting on the time to file the FAFSA. But everything else was already in line. I was going to go for business and entrepreneurship. I was about to start an LLC and try to do like that resale stuff, you know, to get a little bit of a side hustle going on. I was looking for a second job. I bought a bunch of stuff for the place I was living at, which is all gone now, but I bought a bunch of stuff. Like I was on the right track. You know what I mean? And like my next step was either to get my own place, which I was talking to Todd about, which was like the coordinator guy or whatever, and or get a car. You know what I mean? And another thing was like in 2023, you know, I had a bad seizure that like left me like I flatlined all the way through. You know, like they was about to pull the plug on me and everything. And they said, I'm a medical miracle that I should even be talking here today. And like, that messed up my mind a little bit, like, thinking wise and stuff like that. And it's not an excuse, this is documented through Sparrow Hospital. This is all stuff that can be checked into. And like, that's kind of why I'm on Capra and stuff like that, to help straighten myself out. I'm just trying to get, a second chance, man. I'm trying to do the right thing. I don't want nothing to do with prison. I don't want nothing to do with getting in trouble. I don't want nothing to do with none of that. Your Honor, I even, when I was out there, I called the cops a couple times, just to show like I was trying to change. I even talked to John about a couple things that happened because I didn't know what to do. I've never called the cops on nobody before, so I was trying to actually be a productive member. You know what I mean? Like I never done this, and I didn't really have any help. And everything that I was reading was I was supposed to get help, and then I didn't get no help. I got a place to stay. And then the first 3 days, the toilet didn't even flush, and like, and I didn't, everything I bought was with my own will, with my own doing. So, and you can see like all the stuff that was in my apartment, like I got all that, nobody else there in that Phase Motel had nowhere near as much stuff as I had. You can tell I wasn't doing drugs, and I don't really know what else to say. Like I was trying. It was just a bad day. I was sick. I apologize to the court. I apologize to the cops mainly for even acting like that. Like I feel stupid acting like that. I don't even like acting like that. Like I play around, not joke and stuff like that. But but that's with like people that I'm comfortable with. But other than that, dude, I don't talk to people like that. I talk to people with respect. And some type of intelligence. I don't like to do that. I've never came out of my bag with John that I can remember. I don't even think we've even had a bad conversation, and I don't know. John's never done me wrong. I've never done him wrong. He's always been straightforward with me, and I've always been straightforward with him. Blaine to the point. Like at one point in time, I give you an example. At one point in time, I had like a little, it was kind of like a pocket knife thing or whatever. And I was using it to cut boxes up at my work, like cutting them open and stuff. Because I worked at Bears Den, so I cut plastic open. It was real small. It was like the size of a razor blade. John said I'd get in trouble for it, so I ended up throwing it away just because I didn't want to get in trouble for it. You know what I mean? Like I don't even have anything that he said I'd get in trouble for, I just didn't do. I was actually trying.
Okay, well, I did read through the report, so I'm familiar with the incident that brings you before the court here today. I read through the report that contains all the background information about you, your circumstances, your past history, your medical issues and so forth. So I have all that information. I take all of that into account along with what the lawyers had to say, and I listened very carefully to everything that you've had to say here. First of all, I think make a really valid point that you have had a lot of negative experiences based on your prior incarceration. I think it's really understandable that somebody who's had to deal with what you've had to deal with and live the way that you've had to live in prison and the things that you've had to do to defend yourself and keep yourself safe and secure in that environment. You can't just switch that off when you're outside of it. And that, when you're faced with certain situations, that background is going to tend to cause you to have an reaction. Things that a normal person who hasn't been through those things wouldn't do. And so, I think that's completely, again, understandable that you would react in that way. The problem is those officers don't necessarily know what your background is. They're responding to a situation and they have to deal with somebody who is doing the kind of things that you were doing. And because you've had that background in your life doesn't necessarily give you the right to put them in a position.
No, it doesn't. I understand that.
So, and I say that because I think that's a mitigating factor, but it's not one that excuses your behavior in this case.
No.
And so that's one thing. I think what's positive is that you are taking steps through community mental health to address those things so that you can work on strategies to help you react in a different way than you did in this situation. because of your background, and I think that's a big key for you going forward as to whether or not, you know, you're gonna spend more time on the outside or more time on the inside.
Yeah, I agree.
So I say that because I think that's something that I should take into consideration in terms of percentage. As you're aware, your guidelines are 7 to 28 months. I think your conduct in this case and your past history would certainly warrant a sentence at the high end of the range. I think the fact that you are addressing some of those issues and have voluntarily participated in community mental health gives the court reason to believe that there is potential for rehabilitation, and that, you know, it's something that you're self-directing as opposed to being ordered to do it, which I think makes a difference as well. And so in my mind, that moves the sentence from one that's at the top end of the guidelines to one that's more in the middle, because I think that sentence in the middle of the guidelines addresses the positive things that you're doing, but it also addresses the wrongfulness of your conduct in this case. So the court finds that the sentence of 18 months in the Michigan Department of Corrections for 3 years as to each count is a reasonable and fair sentence given all the circumstances in this case. Because of your parole status, you do have credit for 0 days served. Any sentence here is required to be consecutive to any parole violations. Court will order a crime victim assessment of $130, court costs of $325, attorney fees $50, $136 state costs. You have the ability to seek an appeal of the sentence. Now, appellate rights. Did you want this?
Yes, please. These are your forms if you want to file an appeal. There's 4 copies. You're going to initial the top one to indicate that you've received it. You're going to keep the bottom 2 if you want to file an appeal. One of the deadlines is 47 days. So you have to fill those out and turn them in within 47 days. Say the 7th, Your Honor.
It was emailed.
You can email it and attach it.
I look for it.
All right, so you keep those copies. You can fill those out if you will type them if you want to file that appeal.
Get back down. I'm gonna have Mr. Clock remain right there. So got a microphone there that will pick up his voice. And I'm doing that for the safety of both counsel and Mr. Clock himself. So the court will call People versus Caleb Clock. We have 2 files, 255442, 5506. Record should reflect Mr. Clock present here in the courtroom today. Mr. Clock, did you have an opportunity to go through the report about that?
Yes.
Mr. Thompson, are there any additions, deletions, or corrections to that report?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Ms. Koch, any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Do you have any victims that wish to address the court today?
No, Your Honor.
Anything on behalf of the people for Alex?
I'm actually really glad that Mr. Clock sat through the last sentencing, because I think that it's good for him to understand his history is really bad. He's had a pretty tough go of it throughout the last couple of years we've been dealing with him. And when he talks, he doesn't seem aggressive. And then you see these behaviors in the jail, and it's almost as if he doesn't want to get out of jail. It looks like he doesn't want to get out of jail. He just wants to stay in jail. And now he's moving on, and he's, 19 years old, and now he's looking at prison. And then, if he gets out of prison or he gets out of jail, whatever the court sentences him today, he's going to his guidelines are just going to keep going up and up and up. He doesn't have a lot of self-control in the jail. And for him to act the way he did in this case and put people in danger is completely inappropriate. And if he just wants to continue this path, he's just going to stay in institutions until he's completely institutionalized, which is really sad for a 19-year-old. So I hope that, this is the last time that we see Mr. Clock. I hope that the court sentences him within the guidelines. He doesn't have very much criminal history as an adult because he's only 19 years old. He's putting people in danger. If he can keep his head down and maybe get some help for his anger management and his behavior, maybe he can get on the right path. So I'd ask the court to follow the recommendation. Thank you.
Thank you, Hunter. I do agree there's some sort of parallels to, unfortunately, Mr. Lewis being incarcerated for a long time and how Mr. Clark's adulthood is starting out. I really like Mr. Clark. He's 19. We have very positive interactions. I really enjoy talking to him. I really think he has a lot of potential. I think he has a lot of intelligence. I think he's pretty clearly on some sort of spectrum. He doesn't always express things the way a normal person does. And I think that's one of the really interesting and unique things about him. But that's what I see happening when he's losing control in the jail. He did advise and did confide in me that he had been assaulted while he was at the Wayne County Juvenile Facility. And that's part of why he has such he's capable of reacting so negatively when something bad happens, when he is incarcerated and things are not going well. It's really too bad that triggers, because he was on track to, be released here. More than any client probably I've had in recent memory, Mr. Clark is kind of on his own, working through foster care. He essentially had to stay in Michigan as a guardian. Now into adulthood, he has an adult guardian. And again, it's someone from the state. He doesn't have family support. It's really too bad. He is in line. If and when he does get released, he's probably gonna need to end up being in an AFC home. I talked to Caleb about boot camp. He's really excited about it. I think that is a really good alternative for him. I don't know that a 19-year-old doing long-term, months in the Crawford County Jail, I don't know that he's able to fulfill his potential in there. I think boot camp would be a really good chance for him to use some of that 19-year-old energy to try and grow and try and develop. So I really do think he's someone with a lot of potential, and I really do have high hopes for him, and I hope the court will sort of see him as that whole picture in terms of his background and what he's been through. Nobody's excusing what he did. It's really unfortunate that happened. I know Caleb feels bad about it, and I hope he takes the opportunity to apologize for it. Thank you.
Thank you, Mr. Clark. Was there anything you wanted to say today? The record should reflect Mr. Clark. I will shake his head no. Mr. Clark, I did read through the pre-sentence report. You've been in front of me before on a different case, the probation case that we're going to talk about in a second. So I'm well familiar with your background and your history, and through that report, what happened in this case. And I agree with Mr. Thompson. It's really unfortunate. You haven't had much of a safety net in your life to help you teach you the right way. And I think that, in addition to probably some mental issues that are something that are have developed over time, or you were just born with, have all combined, create a situation where you would act out in ways that are out of control. It's unfortunate that we don't have a mechanism that can better deal with those kind of issues. Complicating factor is that you get violent, and so the number one priority for the court and the community is to have to make sure that everybody else is safe when you act out. That means, unfortunately, having some tighter controls on you, which I think contributes to the problem rather than solving it. But don't have any other good help. Yeah, of course, the safety of others is a primary concern. So I do present significant to yourself and to others the way that you reacted. In terms of the recommendations here, I do think that they're appropriate. It sounds like you may be eligible for the boot camp program. If you are, that's something I certainly would consider for somebody at your age as an intervention, as a way to maybe try to interrupt the cycle that you're in. And so that's something the court court certainly would consider. You're a young man, and I'm not going to sentence you at the top end of the guidelines primarily for that purpose, because of your age. There still has to be hope for some rehabilitation here. But at the same time, I think there needs to be a significant penalty here. The guidelines in this case are up to 29 months, 2 months. 1 to 17, the other 14 to 29. So the court finds it a sentence of on the charge of the assault of behavior, the 14 to 29 charge, the court finds that an appropriate sentence would be 24 months to 5 years. As to the R&O charge, the court finds that an appropriate sentence would be 17 months to 2 years. I'm sorry, 16 months to 2 years. You have credit for 92 days served. The court is going to order a crime victims assessment of $130, court costs of $325, attorney fees of $350, $68 state cost as count 1. That's account for a $68 state cost. You have the ability to seek an appeal of the sentence, and Mr. Thompson can provide those color rates.
You can initial it, copy for me. Or now, captain. 14 days. Fill that out, kite it out, and we'll start the appeal process.
Thank you, that's all. For this.
Your Honor, we have his probation violation up too. Could we just discharge him unsuccessfully and dismiss the probation violation?
Address that. Thank you.
Thank you, Your Honor. Prepare that order.
Right there in Macomb, is your name Mr. Donegan?
Yes, Your Honor.
Donegan, it might just be a second. We're waiting for your attorney to connect. You can just stay on the line there for a minute.
Yeah. Come on.
Rachel Wagner.
She is the victim's mother on Donegan.
I'm Donegan.
Yes.
Mr. Thompson, I do have Mr. Jackson connected. Want to take that? Mr. Jackson, if you can hear me, we need you to unmute yourself.
What is it? Just the mobile detect and the true north.
Mr. Jackson, if you can unmute, please. Thank you. Are you Christopher Jackson?
Yes, sir.
Okay, can you hear me okay?
Yes, sir.
All right, we'll go on the record in People versus Jackson. This is file number 255496. The record should reflect Mr. Jackson's appearing by video by prior approval of the court. If I could have counsel put your appearances on.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson, on behalf of the defendant, Christopher Jackson. Your Honor, we do appreciate the court allowing Mr. Jackson to appear by Zoom. We are going to be asking for an adjournment today. I do not have the state crime lab test results of the substance that's alleged to be methamphetamine in this case yet. I have a roadside true narc, which I don't believe is admissible, but we don't have it for the crime lab yet. It's a fairly new case. I think if we have a short adjournment, my client really wants to see those labs. There is a dispute about what the material is.
All right, Ms. Koch, any objection to that?
No.
Mr. Jackson, were you able to hear that?
Yes.
Is that how you'd like to proceed with your case as well?
Yes.
Mr. Thompson, how much time should we?
I'm hoping 60 days, Your Honor. Again, this is a fairly new case, and I will say Mr. Jackson has been in.
Yeah, I don't know the judge.
So I'm hopeful 60 days will be enough time for the labs to come in and
Yeah, I already went.
about this.
Look it up on Facebook. That's what I was like.
Jackson, you need to, whoever's talking, they need to stop. We're trying to make.
Sorry about that.
No.
All right. So we'll set this for hearing in about 60 days for a plea hearing. So Mr. Jackson, between now and then, you need to stay in touch with your attorney. So when we're back for that next hearing, to the extent that there's any plea offers, you'll need to be ready with the final decision as to whether or not you're going to accept any plea offers or whether you'd like to go to trial at that time. Do you understand that?
Yes, I understand.
All right. Mr. Thompson, anything further for the record today?
Nothing further for today's record. Thank you.
Ms. Cope?
No, nothing further. Thank you,
All
Your
right.
Honor.
And Mr. Jackson, for that next hearing, if you do request to appear by Zoom, which again, I generally have an objection to, at that next hearing, you need to be, in a room where it's quiet, where things going on around you aren't going to disrupt the proceedings. Otherwise, I'm going to require that you appear here in person, okay?
I understand. Yes, thank you.
All right. Okay, thank you. That's all for today. You're free to disconnect at this time.
All right, thank you.
Mr. Truce, are you able to hear me okay? Okay, we have Mr. Donegan connected from Macomb County, so we'll go on the record in People versus Donegan. This is file number 255510. The record should reflect Mr. Donegan is appearing today by video from Macomb County Jail. If I could have counsel put your appearances on.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Trush, appearing on behalf of Mr. Donovan. Your Honor, in regards to today's hearing, I'm going to request that the court reschedule this, and I would suggest to the mid-motion day, and that we try to have Mr. Donegan transported. Our phone system, I cannot get in touch with him in Macomb's jail. The correction staff there basically has referred me to their system, which is we can't seem to get it navigated. He has a similar charge in Macomb. We have an offer here that has significant advantages, but I don't know that we can really assess it all that much without knowing what's happening in Macomb. So we're really not in a good position to move forward right now. And again, I think I need to have some discussions with him about what's going on in Macomb and how those things fit together. There's a lot to unpack here.
Right, let's go.
It will probably be difficult to transport him from Macomb, but obviously that can be done. They had a hearing of some type in the middle of December. We're gonna be going back and forth with these same issues. Well, we don't know what's gonna happen in Macomb. We don't know what's gonna happen in Crawford, and we're gonna be going back and forth. But if we adjourn it out, we don't have a mid-motion date this month. It would be the first week of February. There is an offer. The offer is to plead to and add count 4 criminal sexual conduct, 3rd degree, and count 2 child sexually abusive material, aggravated possession, dismiss counts 1 and count 3. So if we want to adjourn it, that's fine. The plea will be revoked at the next hearing.
Okay, so Mr. Trush, I will set this for an in-person hearing here in February. So Ms. Coke, if you can prepare that writ. And I understand it's an expense to Crawford County. I certainly, try to avoid that whenever possible, but at some point we need to be able to move forward with the case. Ms. Coke, I don't know if you want to talk to our jail and if they want to call Macomb and, tell them, hey,
Right now, I'll work on that.
Let us talk to our guy. Maybe they can work out something between the two of them to avoid that expense. But at this point, from the court standpoint, I need to be able to move forward with this case. If Macomb's not allowing illusions, we have to do what we have to do.
Okay, thank you, Your Honor.
So, Mr. Trush, anything further with regard to this file?
No, Your Honor. I appreciate that, and again, I would just emphasize it doesn't happen often, but it's very impractical when the jail is 3.5, 4 hours away. It's not as if I can just easily go up there and talk to him. I have to use their systems, and it's proving to be a significant barrier.
Okay. All right, I had to mute Mr. Donegan. I had to mute you because we had some background noise. Raise your hand if you have any questions at all about how we're going to proceed with your case. Okay, Mr. Donegan's indicating he doesn't have questions, so we're going to go ahead and disconnect at this time. Thank you.
Thank you.
Mr. Trush, I also have Wexford connected with Mr. Vogler. Let's see if we can get them to turn on their camera. What's your name?
Crow.
And sir, what's your name?
Wait, well,
Mr. Walt. Mr. Truce, are you ready on Mr. Walt's case?
We are, Your
Oh.
Honor.
Hold on, we have Wexford connected. Is that Mr. Vogler there?
Yes.
Okay. All right, we'll go on the record in People versus Sean Vogler. This is file number 255500. The record should reflect Mr. Vogler's present by video from Wexford County. If I could have counsel put your appearances on.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Trush, appearing on behalf of Mr. Volger. In regards to this case, Your Honor, frankly, until yesterday, I hadn't had contact with Mr. Volger since the preliminary exam. Tuesday afternoon, I was notified by the prosecutor's office that he was in Wexford's jail. I was able to speak to him yesterday. I went over the offer with him, and frankly, I think we have an offer that we'd be willing to accept. However, he did indicate to me he has Kalkaska County charges, which is what has him in the Wexford jail right now. And frankly, I don't think I would be doing a very good job if I didn't talk to his Kalkaska attorney about what's going on there before we resolve this matter, since I think they are substantially similar charges. And again, our offer here, while beneficial, might put him in a worse position there. He did indicate to me that Mr. Seeger is his attorney over there, but I haven't had an opportunity to get in touch with him since yesterday. So I would ask to cancel his bond at this time, since he's indicated he cannot make his bond in Kalkaska, and ask the court for a 30-day adjournment. I think this is our first status conference.
Could I say something?
Vogler?
Could I, is it possible to be let out to go to treatment while we adjourn this?
Well, Mr. Vogler, you've posted your bond here. I mean, the issue is going to be if Kalkaska is willing to let you out to do that.
Right.
We can leave your bond in place here if that's what you'd like, but you run the risk then of not getting credit for this time here.
I understand that. I just figured I could ask now because this is Judge Mertz is the same judge.
Well, I can tell you this, Mr. Trush and Mr. Vogler, we had Ms. Anderson present today by video on behalf of pretrial services. Part of what we had up for today was a hearing, a show cause for bond violations for failure to test. So in light of that, Mr. Vogler, I would consider treatment if you're eventually found guilty either by a jury or by pleading guilty. I certainly would consider treatment as part of a sentence in this case. But in terms of allowing you to get out and go to treatment prior to that, I'm not in a position based on your behavior so far on bond where I would allow that. So I think, Mr. Trush, your initial thought of canceling the bond might be in Mr. Vogler's best interest at this point, but I don't know if you want to talk to him about that further or what you.
No, that's fine, Your Honor.
So that's how we would ask to proceed.
Okay, so I'm not going to proceed then with the show cause on the bond because the court's simply going to revoke the bond again by request of the defendant so that he can obtain credit here. But Ms. Anderson, thank you for being here on the record.
Can we get a sooner date than 30 days?
Yep, and then we'll set this for a hearing in about 30 days.
There's no sooner date I can get, Your Honor?
No, there isn't, I'm sorry.
Make sure it's right.
Mr. Trush, anything else that we need to address on this file today?
No, Your Honor.
Okay, all right, thank you, Mr. Vogler. We're gonna disconnect at this time.
Mr. Trush, can you come see me, please?
Absolutely.
Bond is your
Thank you.
Okay, Mr. Walt, if you'd like to come forward to the podium, please. The court will call People versus Dwayne Walt, file number 255477, right up here, sir. Oh, do you have a problem with your foot?
Yeah,
can
but that's
sit if you
okay.
want.
It's okay.
If it's gonna cause you
No,
distress.
I'm okay.
All right, if I could have council put your appearances on.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Trush appearing on behalf of Mr. Walt.
Okay. The record should reflect that Mr. Walt's present here in the courtroom today. This is the date and time set for a sentencing hearing. Mr. Walt, did you have an opportunity to go through the pre-sentence report?
We did. We did.
Mr. Trish, are there any additions, deletions, or corrections to that report?
The only correction that I would make to the report is the adult criminal history section entry entry 16 of 16 is a Clare County case. It indicates that it's pending. I believe that's been resolved and he served his sentence. I think he was released from Clare County's jail yesterday.
Or yesterday, yes. Okay, Ms. Coe, do you have any objection to that correction or update, I guess, more like?
No.
Okay. Do you need any more information than that, Mr.?
Well, just like the final charge.
Well, it's 2 attempted RNOs.
Okay.
Which I agreed on. I was in jail for 73 days.
What is that? What they gave you 73 days?
73 days, no more time served when I went to jail. And then I'm on 9 months probation now. So they did put me on probation. So I don't know if that.
All right, gotcha.
I didn't think that was coming. I didn't see that coming at all. But as it stands now, I am on probation. So if there's a thought about that at all with sentencing, okay, there's a consideration to be done there, then I would appreciate it. But that's all I have to say.
All right. Mr. Trush, any other corrections?
No, Your Honor.
Any other challenges to the scoring of the guidelines?
No.
Anything on behalf of the people for allocution today? Or I'm sorry, got ahead of myself. Ms. Coe, do you have any additions, deletions, or corrections?
No.
Do you have any challenges to the scoring?
No, I just want to confirm his bond was not canceled. So my notes say 9 days credit. I don't know I'm not sure if there's additional credit because of the Claire thing that we didn't know or not. I just want to make sure
I
anyone.
have 9 as well.
Okay.
I
Thank
think
you.
9 is correct.
If I may.
You can, I'm gonna give you a chance to say whatever you want in a second.
Okay.
Let me have everybody else take their turn. Ms. Coe, anything you wanted to say for allocation?
Your Honor, Mr. Walt presents, he's 43. He's got 11 misdemeanors and 3 felonies. He's had a series of issues recently. I know he's had some medical issues. I have notes from our November hearing that he was in the Clare jail and had a bone marrow disease. We discussed revoking his bond, but the reason, and this is why I asked the court, the reason we didn't revoke his bond at that time is they said that if we revoked his bond and they were going to release him for treatment, which they didn't know at the time to do the bone marrow treatment, if we revoked his bond, then he would just come here instead of go to the bone marrow medical treatment. So if we didn't revoke his bond, that's why we discussed it on the record at length at that court. And I just want the court to know that's what happened and why he didn't end up getting that credit for the time that was served because of his bone marrow disease. The recommendation is 60 days with 9 days credit. It may be appropriate for the court to take into consideration some of that credit that he would have got if he didn't have that, because we weren't really sure what was going to happen with the Clare County Jail. But I defer to the court and thank you.
Thank you, Your Honor. I think what the prosecutor outlined here is accurate. And I mean that she identified at the last hearing, there was discussion of canceling his bond. We ultimately didn't ask the court to cancel it because we didn't want to put him in a position where if he needed to be released for treatment, we had to scramble and try to do something in order for him to be able to get medical attention that he needed. So I would suggest to the court, the recommendation here is 60 days. He's just finished serving a 73-day sentence in Clare County. Again, was literally released yesterday. He's on probation to Clare County. I would suggest to the court, I don't think he's entitled to credit for that time, but I also don't think the court has to turn a blind eye to the facts of the situation here, which is he just served a jail sentence commiserate with what's recommended here. I would suggest to the court, deviating from this a little bit would make sense to me in terms of placing him on a probation that mirrors the probation, in Clare County. I think that's an appropriate way to handle it. And it takes into account Mr. Walt's unique circumstances. Thank you.
All right, thank you, Mr. Walt. Anything you want to say?
Well, I just wanted to say, I'm truly apologize for the situation that I'm in right now. To be honest, and it sounds funny, but I got gray hairs on my chin now, and it really affected me. Like it sounds simple and stupid, but it really means a lot to me. I think I finally got it. I think I finally figured it out. What's more important in life? My wife's gonna take me back. My kid misses me so much. He's just been so wonderful the last 2 days. So I apologize for anything, and I feel like I've done a lot of growing up, considering I sat in jail for something I didn't do, and I took that as a blessing. It was a blessing in disguise for me, because it saved me a lot. So that's really all I have to say. Thank you.
All right, I did read through the pre-sentence report, so familiar with why you're before the court here today, the circumstances of this offense. There's also a lot of information in that report about you, background and circumstances as well. You have a lot of factors working against you at this point. You've developed a relatively lengthy criminal history, and to the extent that you're saying that you're tired of this, now is the time, because your guidelines are only going to go further up, and you're going to end up spending time in prison. Looks like so far, been there once.
Yeah,
you got 7 probations, 6 jail, 1 prison sentence. So sooner or later, whether it's me or a different judge, is going to look at that and say, we're done with probation, we're done with jail, there's no point to that anymore, because none of it's worked. So to the extent you're going to make a change now is the time to do it. In terms of this offense, it's not a particularly serious offense. You had a relatively small amount that appears that it was a personal use amount. So there's no indications of trafficking or that type of thing here, which would call for a more serious penalty. I do think it's appropriate to take into account the time that you served in Clare County, that had your bond been canceled here, it would have essentially subsumed, or perhaps even more, or close to the 60-day sentence that the court would impose here. The guidelines are 0 to 17. Taking all things into consideration, the court is not going to impose any additional jail time here today above 9 days served at the time you served in Clare. And I think the fact that you are on probation in Clare also gives this court some degree of security, knowing that you're going to be supervised for at least the next 9 months, tested, which is not something that I was going to order in this case. So the court is going to essentially limit your penalties here to time served and financial penalties, which are not insignificant. So the court is going to impose 9 days in Crawford County Jail with credit for 9 days served, the crime victim's assessment of $130, court costs of $325, attorney fees of $350, and the $68 state cost. You have the ability to seek an appeal of this sentence. Mr. Thompson, could you help Mr. Walt? Mr. Thompson is court-appointed attorney, says it's the church. He's going to provide you with some papers here. He's explaining to you how to seek an appeal as well as how to request a lawyer to help with it.
These are 4 copies of the form you'd use to request an appeal. conditional and date this one. We'll give it to the court, just in case you've received it. This doesn't file the appeal. If you wanted to file the appeal, you take the 2 copies that we've given you. You send one to the address on the form.
Well, before you leave the.
Good luck.
All right, versus Kroll, file number 255497.
Mr. Crowe, the podium, Your Honor.
Yes, please, Mr. Kroll, if you want to come around here.
Sierra Cook on behalf of the people. Your Honor, Mr. Kroll had several cases, I think on Tuesday, that got sent up and we came up with a global resolution. There's one on the docket for today. There's 2 that got bound over. I don't know if the paperwork got done. But we did a plea agreement and it has all of those new cases on it too.
If I can approach, Your Honor. Well, yeah, I'll hand you that one to kind of show you the structure, and then Mr. Cole is signing one. He had signed mine, but it's got handwritten scratches on it, so he typed one up, it's better.
Sarah went into overdrive and got all of these.
Yeah, so I do have extra copies for probation.
So on the plea agreement, I do not need that. I did for sake of keeping things try to simple, the 1-3, I kept it, I think it's 5513 and 5512. I was able to do that. So on mine, when I gave judge this morning, has the corrected circuit number.
Perfect, thank you.
Well, under the plea agreements, as the file that was set for hearing today, which is 5497. That's going to be an added count 2 of the lesser charge of larceny. What is the maximum count beyond the added count 2 of larceny, 1,000 to 20,000?
It is 5 years.
I agree with that, Your Honor.
Okay. And then
That added count 3 is going to be the misdemeanor stalking, so it's a 1-year max.
okay.
And then the third and final count, the count 3 is breaking and entering with intent. That's a 10-year felony.
So I'm just going to repeat that with case numbers just so that the record is there. So in case number 5497, Mr. Pearl is going to plead guilty to an added count 2 of larceny, 1,000 to 20,000. Dismissal of count 1. In file number 265513, he's going to plead guilty to an added count of 1 year stalking for dismissal of 1 and 2. And in file number 5512, pleading to count 3 as charged with dismissal of counts 1 and 2. Is that all correct, Ms. Cole?
Yes.
Mr. Kroll, have you had an adequate opportunity to talk to Mr. Thompson about this plea agreement?
Yes, Your Honor.
And what we've said here on the record today is that the agreement that you discussed with him.
Yes, sir.
Is that how you wanted to proceed today?
Yes, sir.
Can you raise your right hand, please? You solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God.
I did, Your Honor.
Thank you. Mr. Kroll, are you currently on any kind of probation or parole?
Yes, Your Honor.
What is that out of?
So I have probation out of Crawford County for MDOP last year of 2024.
So that's with your district court. Are they going to violate your probation based on these charges?
I believe there is a court case or a hearing coming up for probation violation.
Yeah, I suspect they'll drop it, given that these are all resolved, but that's not part of it.
Okay, so you understand that you could face an additional penalty in that case if they find you violated your probation for these cases?
Yes, sir.
And then in file 5497, you're going to plead guilty to 1 count of larceny at $1,000 to $20,000. That's a felony that carries with it a maximum possible penalty of up to 5 years. You understand that?
Yes, sir.
And in file number 265513, 1 count of misdemeanor stalking that is carries with it a maximum penalty of up to 1 year in jail.
Yes, sir.
And then in file 265512, one count of breaking and entering with intent, that's a felony that carries with it a maximum penalty of up to 10 years. You understand that?
Yes, sir.
With all those things, are there any consecutive, either mandatory or discretionary? With all of those penalties in mind, then how did you want to tweak each of those charges today?
Guilty, Your Honor.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial to question those witnesses. You have the right to have the court order any witnesses on your behalf here at trial. You have the right to remain silent during a trial, to not have that silence used against you, and the right to testify at a trial yourself if you want to. You understand all of those rights.
Yes, Your Honor.
Yeah, I have to correct the record. I shook my head. I believe technically the court would have the discretion to make the breaking and entering consecutive to the larceny because he would have been on bond for the larceny. So it's discretionary.
Okay. So, Mr. Kroll, when I was talking about those maximum penalties, there's a thing called consecutive sentencing that you would have to serve the sentence in one case and then you would start the sentence in the next case, as opposed to serving the both at the same time. Does that make sense?
Is that the difference between getting double time?
No, that's a little bit different. But in this case, because you were on bond for the larceny, when you committed the breaking and entering, I, as the sentencing judge, could decide, let's say if I gave you 1 year for the larceny, I could decide to sentence you to 1 year on the breaking and entering and have them run back to back. So you would have to serve essentially 2 years. Whereas concurrent sentencing means you, even if you got 2 sentences of 1 year, they would both be served at the same time. So you only serve 1 year.
I understand, Your Honor.
It's discretionary, which means I don't have to do that. It's not automatic. You understand that?
Your Honor.
Does that change anything about your willingness to enter into this plea today?
Are my guidelines still relevant?
Your guidelines will remain exactly the same. That won't change the guidelines.
Then I'm good, Your Honor.
Okay. As we were discussing all the rights that you have, you said that you understood that you do have all of those rights, including the right to a trial.
Yes, Your Honor.
Can you tell me what will happen to those rights after today?
Be waiving them by my own free will.
Also, you don't have the automatic right to appeal the plea that you're making here today or get it reversed. You can only do that by leave, and that means that you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be that. You'll understand that.
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
Not that I know of, Your Honor.
Has anybody promised you anything other than what we said here in court today to get you to plead guilty?
No, Your Honor.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty to each of these charges because you are actually guilty of each of them?
Yes.
With regard to the larceny charge, the information indicates that that happened on or about late August, early September of 2025. Is that the correct time frame?
Yes, Your Honor.
And during that period of time, did you steal some or take some steel plates that belong to Lake State Railway Company?
I did, Your Honor.
Okay. And at the time that you took those items, was it your intent to take them and put them to your own use, whether that's to use them yourself or sell them?
I intended to take them to their salvage yard and return them as scrap as what I believed what they were in the first place.
Okay. Did you own those things? Other than
No.
thinking they were scrapped, did you have any kind of right to do anything?
No, Your Honor.
Did the actual owner of those plates give you any permission to take those and sell them?
No, Your Honor.
Did that happen here in Crawford County?
Yes.
The next matter, which is the stocking matter, the information that indicates that happened on or about November 30th of 2025. Is that the correct time frame for that?
Yes, Your Honor.
Was that based on a PPO scope, or what was the factor?
There was a PPO and a bond condition prohibiting contact with an individual named Marissa Julio. We had contact with that individual. That's sufficient. I can ask those questions.
Yeah, why don't you go ahead?
All right. Mr. Kroll, you're familiar with an individual named Marissa Julio?
Yes, sir. That's my fiance.
Okay. And on November 30th, there was a PPO prohibiting you from having contact with her,
Yes.
and as well as a bond condition,
Yes.
and you had contact with her.
Yes, sir.
And that happened here in Crawford County.
Yes, sir.
All right. I believe that's sufficient.
Yes, the scope.
That is sufficient, Your Honor.
And Mr. Thompson, if you would, then just would
Certainly.
count through.
All right. And as to the third case, there's an individual named Jeremy Craig who lives in Crawford County. Is that correct?
Yes, sir.
All right. Did you enter his a detached garage next to his home?
Yes.
All right. And you forced your way in, correct?
I did.
All right. And you forced your way in to take property out of that garage, including property that belonged to Jeremy Craig.
Yes.
All right. That all occurred in Crawford County.
Yes, sir.
I don't have any further questions.
Ms. Coker, are you satisfied with the factual basis as to all counts?
Yes.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No.
Your Honor, I would just indicate that there was a, part of this was a district court that had already occurred on this file. So just so the record's complete, part of it, we also was pled guilty on a domestic violence. That's evidence.
So are both of you satisfied that the court has complied with statute or law?
Yes.
Yes, Your Honor.
Mr. Kroll, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there's a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea as to each. This will be set for a sentencing hearing and be notified the date and time of that hearing. Between now and then, you'll meet with someone from the probation department for a pre-sentence report. You'll have an opportunity to go through that with Mr. Thompson before the sentencing hearing. If you have any questions about that.
No, Your Honor.
That's all for today.
Thank you.
McGregor, which case are you signing in on?
Your Honor. I am on Michelle's. Sorry.
Mr. Michelle's, okay. And then they're at DOC. Ma'am, can you tell me your name, please?
Corey nephew?
Bring it. Okay. Mr. Thompson, are you on that file?
I am on that file.
Okay, we'll go on the record in People versus Nephew. This is file number 255505. The record should reflect that Ms. Nephew is present by video from Department of Corrections.
Yeah, you can
I
call
think
her.
Okay, if I could have counsel.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of the defendant, Corey Nephew.
All right, Mr. Thompson, can you tell me the status of this file today?
Yeah, by way of pretrial, there is a plea offer. Ms. Nephew is charged with possession of methamphetamine with the potential drug double, as well as a misdemeanor open container. Prosecutor has offered that if Ms. Nephew pled guilty to count one, possession of methamphetamine, she would dismiss the second or subsequent offense, the drug double enhancement, as well as count to the open container. That's the offer.
Ms. Koch, is that a correct statement of the offer?
It is a correct statement of the offer. I do not know if Ms. Nephew is going to take that or we're going to set it for a trial.
You had a chance to communicate that to Ms. Nephew?
Yeah, she's aware of the offer. We spoke by telephone. I believe it was last Friday, but yes.
All right, Ms. Nephew, were you able to hear all of that?
Yes, Your Honor.
Did you want to accept that plea agreement today, or did you want the court to set this for trial?
I'm going to take the plea agreement, Your Honor.
All right, and I'm going to apologize, Mr. Thompson, when you were stating the terms of that. I was monitoring something else on my computer, so.
Yeah, certainly. I do have it in writing. I'm going to go ahead and sign it and put on record for Ms. Nephew's line. But yeah, it's plea to count 1, possession of methamphetamine, dismiss the second or sub, dismiss count 2.
So Ms. Nephew, if you would, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. Ms. Nephew, are you on any kind of probation or parole that would be affected by this plea here today?
I am on parole, Your Honor.
Okay.
Yeah, she was remanded on her parole detainer.
Okay, so she's serving the penalty right now.
As far as I understand, yes. I don't know if that's.
I don't think that's been resolved yet. She's been returned pending this case and then also the Otsego County case.
Okay. So there's no
I would
credit.
say she has exposure on the parole. No, I would not say that. I would agree there's no credit.
Okay. All right. So Ms. Nephew, I just want to make sure that you understand, you probably already know this, but because of your parole status, you would not be entitled to any jail credit on this charge.
Yes, Your Honor.
And you understand that any sentence in this case would have to run consecutive or back to back with any penalty that you might serve for a parole violation.
Yes, Your Honor.
Okay. And then the maximum possible penalty for this charge, which is possession of methamphetamine, is up to 10 years and or $15,000 fine. Do you understand that?
Yes, sir.
With all of those things in mind, what is your plea to that charge today?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want it. Do you understand all those rights?
Yes, sir.
And you understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we've said here on the record today?
No, Your Honor.
Is it your own free choice to plead guilty?
Yes, Your Honor.
Are you pleading guilty because you are actually guilty of this crime?
Yes, Your Honor.
On or about July 23rd of 2025, were you present in Crawford County?
Yes, sir.
At the time that you were present in Crawford County, did you have possession of some methamphetamine?
Yes, sir.
Did you know that that's what that substance was?
Yes, Your Honor.
Did you have any legal right to have any amount of it at that time?
No, sir.
Ms. Koch and Mr. Thompson, are you both satisfied with the factual basis?
Yes, Your Honor.
I am, Your Honor.
Counselor, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
No, Your Honor.
Are you both satisfied that the court has complied with statute and court rule in the case?
Yes, Your Honor.
Yes, Your Honor.
Ms. Nephew, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there's a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. There'll be a pre-sentence investigation done prior to that, and you'll have an opportunity to go through that with your attorney prior to the sentencing hearing. You do have the right to have that hearing in person here in Crawford County, and if you wanted to exercise that right, I would sign an order having you transported here for that purpose. You can waive that right, and we can have that hearing by video like we're doing today. Do you know how you'd like to proceed in that regard?
In person, Your Honor.
Okay, so Ms. Pope, if you'll prepare a writ for Ms. Nephew's transport here to Crawford, and Ms. Nephew, you'll be notified of the date and time of that hearing. Do you have any questions?
No, Your Honor.
Okay, thank you. The court's going to disconnect at this time. The next case is People versus Richard Adams.
Your Honor, I know the court's got a very busy docket today. Ms. Koch and I were hoping to just take a couple minutes of the court's time off the record.
Okay.
Before sentencing.
Is he lodged or?
He's right here, Your
Oh,
Honor.
that's Mr. Adams. Okay, gotcha.
Does the court want to do, Mr. Michelle, so that Ms. McGregor can be done today?
Well, I don't have Mr. Trush connected.
Oh,
so,
okay.
Ms. McGregor, we're gonna have to take a short break. Mr. Trush is not connected. He's in court, I think, with Judge Hunter as well, so he's been trying to go back and forth. So I'm just gonna ask you to stay on the line for just a minute, and we'll get started with that.
Your
case.
Honor, I have a full docket here. That's why I'm sorry. That's why I asked to appear via Zoom. I have a full docket here that I'm on right now. That's why I just got up and left the courtroom. The judge, I asked yesterday to have a headphone in and my phone in there. But if we're in the middle of a case, it might take me a second to get on.
Okay, yeah.
If that's okay. I'm sorry.
No, everybody's juggling stuff today, so we'll make it work.
Okay, thank you.
Counsel, if you want to talk for a minute here on. Okay, let's see. Ms. McGregor, yeah, we do have
Hi, Your Honor.
we do have Mr. Trush connected, so, we'll go on the record in People versus Scott Michelle's. This is file number 255502. The record should reflect Mr. Michelle's is present here in the courtroom today. If I could have both counsel put your appearances on.
Lucy McGregor on behalf of the people.
Thank you, Your Honor. Richard Trush on behalf of Mr. Michelle's.
Mr. Trush, can you tell me the status of this file here today, please, on behalf of defense?
Yes, Your Honor. I believe we do have an agreement whereby Mr. Michelle's will be entering a plea to count one with no objection to treatment under 7411. In addition to that, there are, I think, 2 driving on a suspended license files in the district court. And we've discussed we'll be wind up making an admission to one of those. One of them was just arraigned yesterday, so it's not exactly clear that's how that's going to happen yet, how it's going to unfold. But that's the agreement that we have.
Ms. McGregor, is that a correct statement of the plea?
Yes, Your Honor.
Mr. Michelle's, have you had an adequate opportunity to speak with Mr. Trush about this agreement?
Yes, sir.
And what he said here today, is that the same agreement that you discussed with him?
Yes, sir.
Is that how you wanted to proceed today?
Yes, sir.
Can you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Mr. Michelle's, are you currently on any kind of probation or parole?
Just probation for being on bail.
Okay, like the bond conditions?
Yep.
Yeah, but nothing outside of that?
No, sir.
Okay. And you understand that the maximum possible penalty you could face for this charge would be up to 10 years and or $15,000 fine?
Yes, sir.
Have you ever had any kind of controlled substance related offense in the past?
No, sir.
With that maximum possible penalty in mind, what is your plea to that charge today? Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial, to not have that silence used against you, and the right to testify at a trial yourself if you want. You understand that you have all of those rights?
Yes, sir.
And do you understand that you're going to be giving up and waiving all of those rights by pleading guilty? You won't have them.
Yes, sir.
Also, you don't have an automatic right to appeal the plea that you're making here today or get it reversed. You can only do that by leave, and that means you would have to ask the Court of Appeals to hear your case. If they said no, then you couldn't go any further with that appeal. You'd be stuck with this plea that you're making here today. Do you understand that?
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anybody promised you anything other than what you said here in court?
No, sir.
Is it your own free choice to enter this plea? Are you pleading guilty to the charge because you are actually guilty?
Yes, sir.
This happened on October 23rd of 2025. Is that the correct time frame?
I believe so.
Had you been present in Crawford County at that time?
Yes.
When you were in Crawford County at that time, did you have possession of some methamphetamine?
Yes.
Did you know that that's what that substance was?
Yes.
Do you have any legal right to have any amount of it at that time?
No.
Ms. McGregor, are you satisfied with the factual basis?
I am, Your Honor.
Mr. Trush?
I am.
Ms. McGregor, are you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Trush, are you?
I'm aware of none.
Ms. McGregor, are you satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Yes, Your Honor.
Thank you. Mr. Michelle's, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Before you leave today, you're going to meet with the probation officer to set up a time for the report. And between now and the next hearing, it's important to stay in touch with your attorney, Mr. Truitt, so that you're ready to proceed at that date. And if you have any questions. Thank you. That's all for today.
Thanks.
Thank you. Ms. McGregor, you're free to disconnect at this time.
Thank you, Your Honor. Have a great day.
You didn't have.
Mr. Adams, if you'd like to come up to the podium, please. On the record in versus Adams. This is file number 255414. The record should reflect that Mr. Adams is present here in the courtroom today. If I could have counsel for your appearances on.
Sierra Coca, behalf of the people.
Thank you, Your Honor. Jason Thompson, on behalf of defendant Richard Adams.
This is the date and time set for a sentencing hearing in this matter. Mr. Adams, did you have an opportunity to go through the pre-sentence report and talk to you?
Yes, I did.
Okay. I do want to note for the record that I did have a discussion about this file in chambers with your attorney, the prosecutor, and the probation officer about some matters that I think we've all agreed. Won't put on the record, but you're aware of that conversation.
Yes, sir.
Mr. Thompson, are there any additions, deletions, or corrections that need to be made?
No, Your Honor.
Are there any challenges to the scoring?
No challenges to the scoring.
Ms. Pope, do the people have any additions,
No, Your Honor.
challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocation?
Your Honor, my main concern with Mr. Wakely is not his criminal history, which at 58 only has 1 felony and 2 misdemeanors, but that he's had some struggles appearing for court. He's absconded for some time. I mean, we didn't charge him with that, but he probably could have been charged with it if a report had been submitted. There was not one. He has been subpoenaed to a proceeding in the middle of February. We've just had problems dealing with him throughout his case. The recommendation is 90 days with 47 days credit. I talked to MDOC about whether or not it'd be appropriate to put him on a tether, given that his absconding previously to allow him to get out. It's unclear to me where he's going to reside when he leaves, so whether or not that's appropriate. I think the recommendation is appropriate. I think 120 days would also be appropriate, given that he's absconded. Thank you.
Thank you, Mr. Thompson.
Thank you, Your Honor. Court's reviewed the PSI. The court knows that Mr. Adams was healing with methamphetamine addiction, horrible, highly addictive substance. The court's aware that he was forthright with law enforcement. He's a very cooperative person, in my interactions with him. Very helpful. I understand that there was the period where he was not available. I understand that's obviously a concern for the court. Mr. Adams is doing the best he can. He is trying to focus on remaining drug-free and finding employment and not having those bad associations. He does have his longtime girlfriend who's here today with him, who's a support person for him. I think he can address his living plans when he's released. I didn't know that was going to be so much of an issue today, but Mr. Adams is hoping to do his time and to be released. He would ask the court to consider time served on this. I think the court's aware of his facts and circumstances, but he can address what his plan is for when he's released, where he's going to reside.
All right, thank you, Mr. Adams.
No, sir.
So, Mr. Adams, I did have a chance to review the pre-sentence report, so I'm familiar with certifications and report the court here today. There's also a lot of information in that report about you, your background, history, and so forth. So, I've got all of that information. As I indicated, I did have a discussion with counsel about another mitigating factor in chambers. So, I'm fully aware of all the circumstances involved in the case. There's some things that work in your favor here, certainly. The lack of a significant criminal history, there's been a significant period of time, between your previous convictions and now. The circumstances of this case involved a small amount of methamphetamine, a personal use amount. There's no indication that you were trafficking in part of this. So all of those things are things that help you, of course, in complicated matters. Your behavior that makes this more of a serious issue than maybe it could have or should have been addressed differently. All in all, I think the recommendation is appropriate. I think it's a fair recommendation. I think it takes into account things that work in your favor and the things that don't. The guidelines here call for a sentence of up to 9 months. The lower third, again, I think it takes into account all the factors. It also provides for probation, which I think is important. So I'm going to follow the terms of the recommendation to the extent that you're released prior to or subpoena to testify in another matter. I will approve the use of a tether if that's available. Right. It's not, then it's not. Cross that bridge when we come to it. But in terms of the sentence, I don't find that circumstance can be a reason to give you a more lengthy or more lengthy sentence. That's something that really is not a consideration that I can address through sentencing, other than to say that I think the tether would be appropriate. Yes, sir. So I'm going to file the recommendation, sentence you to a period of probation for 24 months. The court is going to adopt as the conditions of that probation all the terms and conditions listed in the report. The court is going to order that you serve 90 days in the Crawford County Jail. You have credit for 47 days served. If there is a tether available, the court will order that the tether be part of the conditions of your probation up and until the time of your testifying or your subpoena, other matter. The court is going to order a crime victims assessment of $130, court costs of $325, attorney fees of $350, $68 state costs, and $30 per month for supervision while you're on probation. The court is going to order that the probation be served for 2 years. You have the ability to seek an appeal of this sentence. And
Mr. Adams, this is the notice of your, by initialing this one, you're indicating you've received it. If you wish to file an appeal, yep. Initials fine. If you wish to file an appeal, you would fill these out and submit them to the address contained on the item if you don't have postage. So these will go back. By the time you're released, so you get good time. So you get 1 day for every 5 days you've been in. So I got you getting out like 20 some days.
Good luck to you going forward. Yeah.
You can go back with Steve.
Thank you.
Record in People versus Stephen Gildner, file number 255450 and 265515.
Sierra Cook.
Mr. Gildner is present here in the court today.
Sierra Cook on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of Steve Gildner. Your Honor, we have trial set for Monday. The prosecutors made a new plea offer. It's my understanding Mr. Gildner wishes to accept it. He would ask the court to plead no contest on the basis of having ingested some substances that day that affected his memory. The plea plea would be to an added count 3, which is third-degree arson, as well as a guilty plea to count 2, which is threatening a witness. Those are both 10-year maximums. I have scored that with Mr. Gildner and discussed it with him. In exchange, the prosecutor would dismiss the count 1 arson, second degree, which is a potential life offense, and she would also dismiss the separate bringing contraband to a jail case.
Ms. Koch.
That's a correct statement of the offer.
Mr. Gildner, have you had a chance to talk to Mr. Thompson about this agreement?
Yes, sir.
Is that how you wanted to proceed today?
Yes, sir.
Can you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Lower your hand. Mr. Gildner, are you currently on any kind of probation or parole?
No, sir.
All right. And as Mr. Thompson indicated, the maximum possible penalty that you could face for each of these charges would be up to 10 years. Do you understand that?
Yes, sir.
With that in mind, what is your plea to those charges today?
Clothing.
No contest?
Yeah.
Okay. All right. Right now you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes, sir.
And do you understand that you're going to be giving up and waiving all of those rights by pleading no contest?
Yes, sir.
Has anybody threatened you with anything to get you to do that?
No, sir.
Has anybody promised you anything other than what we've said here in court today?
No, sir.
Is it your own free choice to enter this plea?
Yes, sir.
All right. So first of all, I have reviewed the police report. Based on the information, I do find that a no contest plea would be appropriate based on intoxication. And I'm referring to Michigan State Police Report number 213-25. Ms. Koch, have you reviewed that police report?
I have.
Do you agree that the information contained within that report would provide a factual basis for the added count of arson third degree and count 2?
Yes.
Mr. Thompson, have you reviewed that report?
I have.
Would you agree that it provides a factual basis?
I do. I also agree it provides a factual basis for the no contest to be based on intoxication.
All right, the court's going to mark and exhibit that, mark and admit that report as a court exhibit 1. Ms. Koch, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No.
Mr. Thompson?
No.
Ms. Koch, are the people satisfied that the court has complied with statute and court rule in the taking of this no contest?
Yes, Your Honor.
Mr. Thompson?
Yes.
All right, Mr. Gildner, the court finds that your plea is knowing and voluntary. The court is satisfied based on the information contained within Court Exhibit 1 that there is a factual basis to support a finding that you are guilty of both the charges in this case. The court will accept your no contest plea. We'll set this matter for a sentencing hearing. Between now and then, you're going to meet with someone from probation for a pre-sentence report. You'll have a chance to go through that with your lawyer prior to that sentencing hearing. Do you have any questions at all?
No, sir.
Okay. In light of the plea today, we'll adjourn the trial currently set for Monday. And that's all for today.
Thank you.
You want to?
Ms. Moore present?
She's not, I don't necessarily expect her.
Let me go on the record.
Yes.
I would.
All right, People versus Tammy Moore, file number 255490. Record should reflect Ms. Moore's presence. This matter was set for hearing at 10:30. It's now 10:52.
That's correct. I just called in the hallway again. Ms. Moore had also failed to appear in district court on the matter Tuesday, so she's on bench warrant status. She had been in a rehab type facility in Saginaw. She's not there now is my information, and I don't know where she is, so I don't have any further information for the court.
Ms. Koch, in light of the fact that this was set for sentencing today, the court will request that your office prepare a bench warrant for Ms. Moore's arrest. The court will order that her bond be revoked. Once she's arrested, the court will order that she be held without bond until the court can set for a sentencing hearing. Ms. Koch, do you have any objection to that?
No.
Thank you.
We took Sherbert off, correct, by that stiff yesterday. All right. I believe that clears me on this next.
And this, I got a notice that Mr. Pick is going to be 15 minutes late.
Oh.
Should be rolling in here momentarily.
We'll take a short recess before we proceed. go on the record in People versus Amber Henning, file number 55443. The record should reflect the Henning present here in the courtroom today.
Your cook on behalf of the people.
James Dick on behalf of Ms. Henning, who is standing to my right, Your Honor.
Thank you. Ms. Henning, this is the date and time set for sentencing in this matter. Have you had a chance to go through the pre-sentence report?
Yes, I have.
Mr. Dick, are there any additions, deletions, or corrections?
There is not, Your Honor.
Oh, do the people have any additions, deletions, or corrections?
No.
Anything by way of allocation of behalf?
Throughout this case, we've had a couple of different hearings, and I was actually reading back my notes, but in August, she indicated she was admitting herself into rehab at the DOT Caring Center in Saginaw. We adjourned in September. In October, she indicated she was going to the Lion's Den. And then, we did this plea. The plea offer is very advantageous to her. The recommendation is low. I think it's 2 days jail with 2 days credit with no probation. She's had a plethora of other problems as well. She doesn't have very much criminal history. In fact, she has none here as of today, according to the PSI. I know she had issues other places. I really hope that she takes this seriously, because otherwise we're going to just continue to see her. I'd ask the court to follow the recommendation. Thank you.
Mr. Dick, anything on behalf of?
Yes, Your Honor. So Ms. Henning, Your Honor, she did attempt to get into the Lion's Den. One of the reasons she has not admitted herself is because she is still on a medical recommendation, or sorry, medical prescription for Suboxone. The medical provider found or believes that she needs the slow weaning off of Suboxone rather than just a cold turkey cessation of the program. So she has been in outpatient counseling. However, through Bear River, she is going at present. It's only 1 time per month. However, she believes that it has been helping her, and she is staying on track. Her ultimate goal, well, one of her ultimate goals here is to get back into school. She wanted to get into a nursing program, or to finish her nursing program that she began. She is dealing with some financial issues at present that preclude that at this time. However, I told her that I would be willing to speak to her to see if we could figure something out so she could get back into school sooner than later. That being said, Your Honor, I think that the recommendation is extremely fair under the circumstances, and we would ask that the court adopts that recommendation.
Thank you. Ms. Henning, anything you wanted to say today?
That's right.
Okay. Well, I read through the report. I'm familiar with what happened in this particular case, as well as your background and circumstances. It's been a long time. I think you had a 7411 like over 10 years ago, 12 years ago, since you've been in court here. These kind of struggles don't go away overnight, as you well know. It takes a long time. Sometimes it relapses. But the important thing is to continue trying to move forward. It appears that you're trying to do that. This certainly wasn't the most serious RNO or the methamphetamine part of it. But it's clear that you somehow could continue to work. It's that you're working at school are helpful. I think staying away from the folks that were around is probably number one. It's really hard not to use when you're that are. So I hope that you'll try and separate yourself from that life, because that'll help as well. I think the recommendation is appropriate given your involvement here in this case. It's going to impose more financial penalties, which are just as punitive. So I find that's an appropriate way to address the conduct here. The court is going to sentence you to 2 days in the Crawford County Jail for 2 days served. A crime victim's assessment of $130, court costs of $325, attorney fees of $350, the DNA testing fee of $60, and it's $50 state cost. This is a misdemeanor, so there are no written appellate rights, but you do have the ability to seek an appeal of this sentence. If you wanted to do that, you would need to file that within the next 21 days. Mr. Dick would be able to answer any further questions you have about filing an appeal of the sentence. Other than that, you just need to go to the clerk's office here after court. Costs. People versus Baker, file number 255439 and 5488.
You're on behalf of the people.
James Dick on behalf of Mr. Baker, who is going to be standing to my right here, Your Honor.
This is, record should reflect Mr. Baker is present in the courtroom today. This is the date and time set for sentencing. Mr. Baker, have you had an opportunity to go through the pre-sentence report and talk to Mr. Dick about that? Mr. Dick, I am in receipt of a letter from Ms. Bruce. I had a chance to review that prior to the hearing today. Are there any other additions, deletions, or corrections to that report?
In the report, Your Honor, it does reflect that there was no alcohol use history. However, there is the alcohol use history does stem from some years ago. We would like it to reflect I believe the age of his first use was approximately age 15. So
start age 15 years old.
Yes, Your Honor. Yes. Other than that, everything else did seem accurate.
Any objection to that change, Ms. Coe?
No.
And Mr. Dick, are there any challenges to the scoring of the guidelines?
No, Your Honor, there is not.
Ms. Coe, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Do you have any victims that wish to address?
She does not want to speak today.
Anything on behalf of the people for allegation?
Your Honor, I actually have had a couple of people in the community talk to me about Mr. Baker. He seems to have a strong support group. You know, he's 44 years old and he has 2 prior misdemeanors. This started as a situation that probably would have been charged as a 93-day misdemeanor, but for his own behavior and the way he acted towards the police officers. And then we had the next set of incidents. I'm a little concerned with the victim's statement in her PSIs. This is very normal, as the court's aware, in terms of what victims say. But she indicated, you know, this domestic violence didn't happen and I want him to come back home and us to go to couples counseling. And then, you know, throughout this case, we met with her and her sister numerous times and she was sobbing and crying and talking about how scared she was of Mr. Baker. We had several meetings with her that were in that tone. And then, of course, we get this letter. I hope that the court follows the recommendation. It's appropriate. I really hope that Mr. Baker has learned something from this and had some self-reflection. It seems like counseling would be a good thing for him so that we don't continue to go down this path. Thank you.
Thank you, Mr. Dick.
Yes, Your Honor. So Mr. Baker, he did find himself in a handful of issues arising out of one that, like Ms. Cope said, could have likely been resolved much more quickly and efficiently had he. He's had some time to reflect. Sitting here in custody since was it early November when it was revoked? My apologies.
Yeah, October 28th.
October 28th. Okay. So he has had some time to reflect there. When he was first admitted, he had still been taking some medication that was prescribed by his psychiatrist. And since being in here, he has come down off of that. He did have a period where he was not sure what was going on, what was real was not necessarily real as he was coming down and drying out from the use of or being on medication for a long period of time. Mr. Baker has had time now to recollect about how everything happened, what happened, and why it happened the way it did. And he does take responsibility for the things that he was not supposed to do. And he does take responsibility for the incident, the domestic violence incident, although it was although there was some sort of an argument, he did agree that he somewhat overreacted in how he reacted to the situation with dealing with narc. Ultimately, a door hit the victim in the face. He was pushing on it, and he admittedly could have dealt with it in a different manner. The other case, Your Honor, that one, it was resolved with a resisting and obstructing. Mr. Baker was at a point, he was emotional. He was with somebody, the victim in the matter, he had been dating for approximately 6 or 6.5 years. And a lot of things were going on between them during this time period. And ultimately, his head was not in the right space. His alcohol consumption was not where it should have been. Mind you, the PSI does reflect that he had 9.5 years of sobriety after a rehab at Harbor Hall. So I do strongly believe that the actions in both of these matters in part did arise due to his alcohol consumption, substance abuse, and needing some sort of likely some sort of therapeutic guidance, whether it's counseling or some other manner. And it could have perhaps helped him figure out how to deal with everything altogether instead of using substance. At this time, Your Honor, we do ask that the court does adopt the recommendation from the court. The only additional piece that we would ask if the court would consider, I did discuss that this is something that would happen right away, but if the court would consider allowing Mr. Baker in the future, after he does complete some of his counseling and whatnot, that him and the victim would be able to have some sort of contact, perhaps in a therapeutic setting, as I believe was mentioned. And if that's if the court permits it, of course. He violations could end up finding himself in jail or prison. And lastly, in addressing his substance abuse issues, AA did only come to the jail one time while he's been in custody. However, he did attend that session. That being said, Your Honor, leave it at discretion of the court.
Thank you, Mr. Baker. Anything you wanted to say today?
But I mean, I'm here because of my actions. And I do take responsibility for my actions. So. Lots of regret. I wish I would have about things a lot differently. But in the end, it was the way I handled things and the way I reacted instead of responding to things that inherently got me here and not listening to the court's recommendations or the court's orders. Now, so I just know not what to. I know what to do now and not what to do. My head's on straighter. First month here, especially from I was running around circles in my head, nonstop. It was really hard to figure out what was going on. what I did wrong, what I did right, you know, if I did anything wrong, if I did anything right, but you know, I know now that I did wrong, and I apologize for my actions and not listening to the courts and thinking I could, I guess, somehow handle it myself. I know what I have to do now, Your Honor.
Well, Mr. Baker, I did read through the report, so I'm familiar with all the information in there, including the information about the offenses in this case, but also about your background, your circumstances. I also read the letter that Mr. submitted very carefully. So I take all of that information into account along with what the lawyers have to say. What you have to say here. These cases are always difficult because once things settle down, there's lots of different feelings on both sides after the incident is over with. And I completely agree with Ms. Cope. The letter I read from Ms. Bruce is very similar to many letters I've read related to domestic violence. And you know, there's been plenty of studies to show that the cycle that occurs in domestic abuse, and it's always, I think, enlightening to me to see how correct those studies are, and how it plays out in real life, how those letters are so similar from case to case, where there's an incident, the person committing the violence is arrested, they're suffering some serious consequences. Because there's been an incident of domestic violence, it doesn't erase the emotions and the feelings between people, and so the victim then feels bad because they care about and love the other person in spite of what they've done, and they want to see that person get better, they want to help that person, and so they end up writing letters very much like the one that was and so it always puts the court, I think, and others in the position of how to appropriately handle it. I do think that the recommendation in this case makes good sense. It addresses some probation, some oversight for you, some supervision to make sure that you get on the right track, that you stay on the right track during the period of your probation. There's a benefit to you from that under the statute that allows this to come off your record if you successfully complete it. So in my view, that's a win-win. It's a win for the community because we've got some time with you to make sure that you're doing what you're supposed to do. It's a win for you because you can put this in the past and move on once you successfully complete it. So I do think that along with a period of incarceration, which I think is completely reasonable given your actions in both of the cases. So all in all, the court's going to follow that recommendation. The court is going to sentence you to probation for a period of 18 months pursuant to 769-4A. The court is going to adopt as the conditions of that probation all the terms and conditions that are listed in the report. I am going to include paragraph 10, which indicates that you must not have any verbal, written, electronic, or physical contact with the victim, either directly or through another person. You must not be within 500 feet of the residence. Now, in terms of how that stands going forward, I'm going to add the language unless it's approved by your probation agent. Your probation agent at any time can ask the court to amend the conditions of your probation. Your agent's the one that's going to be seeing you all the time. It's going to know exactly what's going on with you on a regular basis, much more so than I will. If your agent feels that you're complying with your probation, that you're following through with things like counseling, and that it's appropriate to resume contact, then I won't have any problem allowing that. So again, a lot of that's going to be largely up to you and how much you rely on this going forward. The court is going to order that you serve 93 days in jail with credit for 74 days served. This is all as to the domestic violence charge and file 543, by the way. $130 crime victims assessment, court cost of $325, state cost of $50, supervision fee while you're on probation, $30 per month. regard to the resisting or obstructing, also 93 days in the Crawford County Jail, with credit for 75 days served on that charge. Crime victims assessment of $130 and a $68 state cost. Those sentences to be served together concurrently. Because this is pursuant to 769(4)(a), there are no formal appellate rights at this time. Ms. Koch, anything further we need to address for the record?
No, thank you.
Good luck.
We have two cases.
Just like it.
So this is the one that he deals with you, so we should cross the.
Okay.
Sorry, it's not order. I read prepared.
I'll wait for Mr. Church. All right, Mr. Church, are you able to hear me okay?
Yes, I can hear you now, Your Honor.
Okay, thank you. We're on the record now in People versus Dennis Woods, file number 235201. The record should reflect that Mr. Church is present by Zoom video on behalf of the surety, in this case, Craig's bail bonds. Ms. Koch is present here in the courtroom today. This was set for hearing for show cause. Mr. Woods, I think, was granted release, pretrial release based on the surety bond that was posted by Craig's bail bonds. Mr. Woods failed to appear for a sentencing hearing back in December. And so this hearing was set today. Woods would appear. Mr. Church, could you just make a record of any contacts that you had with Mr. Woods, if any?
According to my office, we've got a couple of leads on him, but we're going to we're asking for an extension of 30 days to try to make that contact.
Okay, Ms. Koch, do people take any position on that?
Your Honor, I really don't have much to add on terms of the bond. I will say he has failed to appear throughout the case. His first failure to appear was in November of 2023. Eventually he got picked up, a year and a half later. And of course there's a recommendation for jail. Mr. McFalda took his name off that recommendation because the guidelines were so high. He thought it should be a prison recommendation. And of course, Mr. Woods didn't show up. So whether the court wants to give the surety another, 30 days is up to the court, but he has been absconding for this case has been going on for 2.5 years. So thank you.
Yeah, okay. All right, so Mr. Church, the court finds that, given the circumstances and the fact that the failure to appear was in December, a little over a month ago, it would be appropriate to allow additional time, for, your attempts to apprehend and bring Mr. Woods before the court. So, the court will set this for an additional hearing. So, okay, so the court will set this for a next date hearing of February 17th. If Mr. Woods is apprehended or brought before the court prior to that time, then we'll likely take that hearing down, but otherwise that'll be the next hearing date. Did you have any questions, Mr. Church?
No, Your Honor.
Okay, anything
Okay.
further, Ms. Cole?
No, thank you.
Okay, thank you. That's all for today, Mr. Church. You're free to disconnect.
Okay, thank you.
See with Mr. Clare's case as soon as Mr. Truce, are you able to hear me okay?
Yes, Your Honor.
All right, we're on the record now in People versus Joseph Poyer, file number 2554171. The record should reflect Mr. Poyer is present here before the court today. If I could have counsel put your appearances on.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Fuchs on behalf of Mr. Poyer.
Thank you. We're on the record today. We did have a hearing previously scheduled in November. Mr. Poyer failed to appear for that hearing. The court issued a bench warrant. He was apprehended on that bench warrant in late December and has been lodged since that time. The court set this for a status conference today to address that as well as any bond going forward. Mr. Truce, can you tell me the status of this file here today?
So, Your Honor, I've had discussions with Mr. Poyer about this file. Unfortunately, I mean, he hasn't made his intentions on how he wants to proceed completely clear. I've discussed with him what the offer is. And I mean, what he repeatedly will tell me is that what he wants to do is get mental health treatment and get treatment for his mental health, which frankly, I think is a good idea. I think that is something that he needs to address, and I think it's something that permeates the case. However, it doesn't completely answer the question of how does he want to address the matter. I certainly think that there are options in terms of mental health treatment that can have an impact on how the case goes. I've discussed with him things like mental health treatment courts. I've discussed with him things like, jail diversion programs through CMH. But I'm not sure that we're zeroed in and completely dialed in on how it is that we want to, resolve the case ultimately. In terms of bond, I would suggest to the court, Mr. Poyer has been in contact with me in my office consistently. He expressed to me, he suffers from a variety of different mental health issues. He's given me psychological evaluations that he's had done in the past, which outlines some of these issues, and expressed to me concerns, about the hearing, expressing to me that he has agoraphobia. In fairness and in candor to the court, I don't have a specific diagnosis of that yet, and I don't know if there is one out there. But again, he certainly is diagnosed with anxiety disorders, and a variety of other maladies. So it would not surprise me, but again, I can't in good conscience tell the court I have a diagnosis of agoraphobia at this point. So I guess in terms of a bond, I would ask the court to set a bond that he would be able to post. Because again, I do think that the mental health issues are permeating the case. And again, he has not violated any of his bond conditions again, other than the missed court appearance, which frankly, I mean, Zoom might be a middle ground that would allow him to maintain those appearances. Thank you.
All right. What is the current plea offer, Mr. Truce?
Your Honor,
The offer is domestic violence, third offense, dismiss his habituals.
and count two.
Okay, yeah. As well as I think we offered he has a misdemeanor case in district court. I think we offered to dismiss that as well.
All right, so Mr. Poyer, we have to figure out how we're going to go forward with your case first. And there's two options. You can either go forward with a plea agreement, or we can have this set for trial. But we need to determine the outcome of the case where I can address, if you're eventually found guilty either through plea or by a jury, then I'd be more than happy to consider, treatment and those types of things as an option for sentencing. But until we get to that point, there's not much that we're going to do in that regard. So we need to know from you how you want to proceed with your case.
I don't know what to do right now. I need my medication so I can even think straight. Like I'm off balance right now. Like I don't even know what's really going on. Like I just confused. I don't know. I need my medication. They won't give it to me.
Can you tell me what you're confused about?
Just everything, like my mind just feel like I'm suffocating right now. And it's hard to process anything. I can't watch TV, I can't read, I can't do much of anything.
Okay. Mr. Trush, when was the last time you had a chance to speak with Mr. Poyer?
I had an opportunity to speak to him.
Like recently, within the last?
Yeah,
week or
I think
two?
I think it was Tuesday night. And in candor, that was the first time I was aware that this was up this week. That was when I received the notice of the hearing.
Sure.
And again, I spoke to him that evening and talked to him a little bit about what the hearing was about.
During that conversation, which I'm sure is more extensive than what I've had with Mr. Poyer here in the courtroom, did that raise any concerns to you about competency? I mean, what he's indicating to me on the record is that he's having trouble understanding what's going on, not just within this case, but generally.
I haven't had concerns with competency. When I talked to him about the case, I mean, he expresses to me, reasonable ideas in terms of how to defend the case at a trial. He expresses to me and understands the difference between a plea and a trial. So I mean, candidly, my worry is I think a competency eval probably isn't going to do us a lot of good.
Okay. All right. So, Mr. Poyer, you can either plead guilty and admit guilt as to the charges under the plea agreement, or we can have this set for a trial. And if you don't know what you want to do, what my intention would be is to have this set for a trial, and then you would have time to still enter a plea after that.
All this is just me being unstable. It's not me to have any of this anymore. I don't know what to do.
Okay, so I'm gonna go ahead and put this on the trial docket and set it with a plea cutoff. Ms. Cope, how much time do you need to be ready for a trial?
Because he is lodged, he's probably going to take priority. I would say we can be ready in 60 days. Our February dockets are really full. I think we have 9 felony jury trials scheduled in February. So we would ask for March or April. I will say for the record, just so the court's aware, he did fail to appear in his misdemeanor case as well. His parents indicated he had stopped his mental health treatment prior to being arrested and prior to the incident. And he has a pretty long criminal history. So if we're going to talk about bond, I'd like a chance to address that. Thank you.
Yeah, we're going to talk about that in just a second. Mr. Trush, if we set this for March or April, is that enough time for you to be prepared?
Yes, Your Honor.
Okay, and Ms. Cope, how many days of trial?
I would say we could do it in one. If defense is gonna call witnesses, we may need 2. I will probably do a 768 and 404B notice.
Mr. Trush, I'm gonna go ahead and set this for 2 days, just in case we do need extra time for picking a jury, and so forth. And then the court will set this for a final status conference and plea cutoff prior to the trial date.
Could we also have a status conference next month? Just because of what Mr. Poirier said today. I don't want to have it. I mean, that'll be February. We may need 2 status conferences, but I think that'd be better in this case.
Yes. Do you have any objection to that, Mr. Trush?
No, Your Honor. My intentions was to indicate to the court. I will go over and talk to Mr. Poirier. If there is movement or a change in something, I would notify the court. So I'm fine with setting a status conference.
All right, thank you. All right, and then Mr. Trush, was there anything else you wanted to say regarding bond?
No, Your Honor.
Your Honor, Mr. Poirier, and we went over this a couple of different times, has a pretty extensive violent criminal history. Some of it's missing from his CCH, but I was able to put it together through his prior PSIs. But he has a 2001 MDOP, that was a juvenile, a CSC 4 juvenile, a larceny juvenile. In 2002, he has a UDAA. In 2002, he has a flee and elude third. In 2002, he has a UDAA. He did have a domestic violence in 2004 that was dismissed, but he had a conviction for domestic violence and cutting telephone lines, it looks like. In 2006, he had an MDOB less than 200. In 2006, he had an OWI. In 2013, he had another domestic violence. In 2013, he had aggravated stalking. In 2014, he had a malicious destruction of a building less than 200. In 2017, it looks like it was an assault by strangulation in DV2. It's a little confusing from his CCH, but it looks like he went to prison on this. His parents believe that this was the case that he went to prison for 5 years on. And that same year, he had an R&O. Looks like the sentencings were similar in date. And that's his parents had called me when this case started repeatedly. They indicated they were in fear for their life and thought that he would kill them. When he got out, he went right to their house, and I ended up talking to the bondsman. State trooper was present as well. He was getting, I think, his camper or things from his camper. I don't remember how that played out exactly, but he was there immediately upon being released. They were concerned about that. And then, he failed to appear in this case, indicated he wasn't coming because he was agoraphobic. And then in his illegal entry, he indicated the same and didn't appear for that. So I'm not sure if we release him on bond that he's going to appear again. His criminal history, as I said, is pretty violent. And the victims in this case were pretty adamant that they were concerned. He had mental health treatment, but he stopped going to it on his own prior to the incident, according to his parents, who were the victims. Thank you.
Mr. Poyer, was there anything you wanted to say regarding bond?
Yeah, I'm not a violent person.
All right, given your past history, Mr. Poyer, given your failures to appear in this case and your district court case, court finds that cash or surety bond in an amount greater than your previous bond is necessary both for public safety purposes and to ensure your appearance in court. Court will set bond in the amount of $50,000 cash or surety. Court will adopt all the conditions of your earlier bond, which included no contact with Donald or Lori Poyer. So the court will continue those conditions as well. And then the next hearing date will be in February. You'll be notified of the date and time of that hearing, and you'll have an opportunity to speak with your attorney prior to that. Mr. Trush, anything else we can address for the record today on this case?
No, Your Honor, thank you.
Ms. Coe?
No, thank you.
Thank you. That's all for today, Mr. Poyer.
Hey, Mike, when you have a minute, can we talk about that case I just went up? Show up. Parents think that he- I can't really figure out. I know, but I can't. There's things that's what I can't. There's just things that are just missing. Are we off of the internet?